Now, the application by the Guptas to halt the freezing of their assets has been dismissed. They wanted time to determine a representative for their legal battles. Island Site Investment was added as an accused in a case where Gupta associate Iqbal Sharma and others were accused of procurement fraud in the Free State. Senior reporter Aviwe Mtila is at the court with more details. Aviwe, the postponement application was in fact dismissed, but where does this leave the matter around who should represent the Guptas?
Well, that's still to be heard at the Supreme Court of Appeals. You remember that it's the contentious issue that they brought up just after the assets were frozen back in June 2021. In fact, they went to the High Court in August asking clarity on who should represent Island Site Investment when it comes to their legal matters. You remember that the company was under business rescue back in 2015, and since then the business rescue petitioners are the ones that have been hands-on running the company, also representing the company when it comes to the legal affairs. Hence, then the directors, we do understand Atul and Rajesh Gupta and their wives respectively, went then to the High Court in August. That verdict came back on November last year with Judge Musi JP dismissing it, saying that according to the Company Act, the people that are supposed to represent a company that's under business rescue are the business rescue petitioners. They tried to apply for leave to appeal that matter in February this year, and of course that application was dismissed by the High Court. Hence, they've now made another application to the Supreme Court of Appeals. So today and yesterday we were supposed to hear the confirmation of the restraint order that was given out last June, but that didn't proceed. Hence, they brought in an application to halt that proceeding in order for them then to get that clarity from the Supreme Court of Appeals as to who gets to represent Island Site Investment, either the directors themselves or the business practitioners. But of course, we heard today that was dismissed, and Judge Snellenberg saying that in fact this matter must go ahead. So now the dates that have been set are the 20th and the 21st of October, where we'll then hear the 2 days that are set aside for the confirmation of the restraint of the order, the restraint order, I beg your pardon.
So what we expect to happen there on the 20th and 21st is that the representatives, or at least the respondents in this case, will have to show cause why the interim restraint order should not be made permanent. Am I correct?
Yes, Mfundo, I want to take you back to the initial restraint order, which is heard in chambers. You understand it's just the NPA and the judge there basically saying that this is why they want these assets frozen. And the second leg then is what we were supposed to hear today and yesterday, but that being moved then to the 20th and the 21st of October. That's where the accused themselves get to be part of the proceedings and also detail why the assets then shouldn't be frozen and restrained. As we understand, that's where even the NPA gets firmer confirmation in terms of even seeking assets that are abroad, going with a paper in hand, telling those countries that we have this paper that has given us the confirmation of the restraint order. This is what we seek from you. As you understand, Iqbal Sharma, for example, has assets that are abroad. The Guptas at this stage, their whereabouts unknown. Those proceedings still happening on the background to try and get them back into the country. I actually put it to the NPA's investigating directorate, since you were if this is not a win-win situation, and she said it's not, but there are indications in terms of the technicalities, given that Mike Helens wanted a 4-week postponement. You do know that that was dismissed, but the date that's been set is only in October, meaning that they technically got what they wanted, even though it was dismissed. But of course, the NPA will tell you that they won this matter, given that they got that application dismissed and the costs have been reserved. The one thing that we didn't get today from the judge is the actual explanation as to why this application was dismissed, giving assurance that that will only be out on Monday, given to the relevant attorneys as to why exactly the application from Island Site Investments directors was dismissed today.
All right. Just Aviwe, for clarity again, you're saying the matter at the SCA, do we know the exact date when it will be heard? Just to see if indeed it is a win-win, where maybe their matter will be heard just before they go to court for this particular one around the restraint order being made permanent.
We're not sure of the date when that matter will be heard, the appeal at the Supreme Court of Appeal. Hence, the NPA here was suggesting that this application was disingenuous, given that there are no timelines if the postponement is granted as to when then this confirmation of the restraint order will be heard.
Yes.
They have many avenues, the island side directors, in terms of even taking it further. If they are to lose, for example, at the Supreme Court of Appeal, they still have that option to go to the Constitutional Court, given the money, of course, in their pockets, to take it there, to make a further appeal. Hence, the NPA was suggesting that this application is disingenuous and, in fact, is just a time delay tactic, given that the court application, of course, the criminal factor of this matter will be heard in January next year.
So it's most certainly not a win-win. In fact, what Sindisiwe Siboko said is that the ID did win at least today. But thank you very much for that update. That's senior reporter Aviwe Mtila.